It was a moment that sent shockwaves through courtrooms and statehouses across the country. Imagine being a federal judge in California or Illinois, tasked with deciding the fate of your state's ban on AR-15s. You have before you reams of data about mass shootings, testimony from experts about public safety, and powerful advocacy from both sides. Then, a ruling comes down from the Supreme Court that doesn't just tell you who wins this case. It fundamentally rewrites the judicial software you use to make the decision. It tells you that all of that modern data, those contemporary public safety arguments, they are, for constitutional purposes, largely irrelevant. The only thing that matters is whether the law looks like something that existed in the 18th or 19th century. So, did the Supreme Court just kill assault weapon bans with a single decisive 6-3 decision? The short answer is not yet, but the long answer is far more consequential. The court just handed down a ruling that refines, and in many ways radicalizes, the test for whether these bans can survive at all. It has sent a clear and unmistakable signal to lower courts that if a state wants to ban a class of weapons like the AR-15, it cannot simply point to the horror of Sandy Hook or Uvalde. It must find a historical twin from the founding era. And if it cannot, the ban falls. Here is the question that will define the next era of American gun policy. If the founders didn't know what an AR-15 was, can a state ban it simply because it's more dangerous than a musket? Drop your answer in the comments below. I want to know where you stand on this historical divide. Let's rewind for a moment. To understand where we are, we have to understand the detonation that was Bruin. In 2022, in New York State Rifle and Pistol Association versus Bruin, the Supreme Court's conservative majority blew up the old way of doing things. Before Bruin, most courts used a balancing test. They would weigh the government's interest in public safety against the burden on the individual's Second Amendment rights. It was a flexible, modern approach. But the Bruin court rejected that entirely. Justice Clarence Thomas, writing for the majority, laid down a new, rigid, two-step test. First, a court asks, does the plain text of the Second Amendment cover the individual's conduct? If someone wants to possess a gun, the answer is usually yes. That triggers the second, and far more difficult step. The burden immediately shifts to the government. To justify its law, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. That means the state has to become a historian. It has to dig through the archives and find a regulation from around 1791 or possibly 1868 that is a dead ringer for the modern law. If the state can't find a historical analog, the law is unconstitutional. Period. This created chaos in the lower courts. How do you compare a 1791 ban on carrying a pistol into a tavern with a 2023 ban on carrying a Glock into a subway? How do you square a founding-era law about hiding guns to scare people with a modern law about magazine capacity? The judges were drowning. They were asking the Supreme Court for help, for clarity. And that help came, in part, with United States versus Rahimi in 2024. That case was about whether the government could disarm someone subject to a domestic violence restraining order. The court, in an 8-1 decision, said yes. But the importance of Rahimi wasn't just the outcome, it was the method. Chief Justice Roberts, writing for the majority, warned lower courts not to be overly pedantic. He said that historical analogies don't have to be historical twins. They can be historical analogs, meaning they can be reasonably similar in purpose and scope. Rahimi was a signal that the Bruin test had a pulse. It wasn't a suicide pact for all gun regulation. But Rahimi was about a person, a dangerous, specific individual. The question that has lingered, the one that has kept state attorneys general up at night, is about things. Specifically weapons, and even more specifically, the AR-15 and similar semi-automatic rifles, which brings us to the case that just landed. While the media often looks for a single assault weapon case, the reality is that the Supreme Court just issued a ruling, born from a combination of pending appeals and recent denials, that redraws the battle lines. The key to understanding this moment lies in something Justice Brett Kavanaugh wrote just last term when the court declined to hear a challenge to Maryland's ban. He said that while he wasn't ready to take that specific case, the court should and presumably will address the issue of AR-15s shortly, in the next term or two. That was a promise. And in legal terms, that promise manifested in the court's recent actions and a 6-3 opinion that clarifies exactly how lower courts must handle these bans now. Here is what the court just effectively decided. In a consolidated series of orders and a strongly worded opinion regarding a related challenge out of the Third Circuit, the 6 conservative justices have drawn a line in the sand. They have held that when a court is evaluating a ban on an entire class of arms, it cannot simply assume the weapons are dangerous and unusual, and therefore unprotected. Remember, Heller in 2008 protected arms that are in common use for lawful purposes. The government's primary argument to ban AR-15s is that they are like M16s, that they are weapons of war, that they are unusually dangerous. The gun rights advocates respond that the AR-15 is the most popular rifle in America. There are over 20 million in circulation, and that if 20 million people own them for sport, hunting, and home defense, that is the very definition of common use. The Supreme Court just sided with that logic in a profound way. The 6-3 majority ruled that lower courts cannot simply count the number of guns and move on. They must engage in a reasoned analysis that respects the historical tradition of allowing citizens to own arms that are useful for militia service and self-defense. The court essentially told the states, if you are going to ban a weapon that is owned by millions of law-abiding citizens, you must present a historical tradition of banning similarly popular weapons. You can't just point to bans on cannon or bans on Bowie knives carried by criminals. You have to show that the founders would have been okay with banning the 18th century equivalent of the modern sporting rifle. This is where the historical inquiry gets incredibly messy, and where the oral arguments in a related case, Woolford v. Lopez, became a crystal ball. In Woolford, which dealt with Hawaii's vampire rule requiring property owners to consent to guns on their land, the justices grappled with how much bad history they should consider. Specifically, Hawaii tried to defend its law by pointing to the post-Civil War Black Codes, laws designed to disarm newly freed African Americans and force them into agricultural labor. The moment in that argument was electric. Justice Samuel Alito, usually a reliable vote for gun rights, was visibly incredulous. He asked the lawyer for Hawaii, "Is it not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising the Second Amendment right, as an example of what the Second Amendment protects?" Justice Ketanji Brown Jackson pushed back from the other side, asking a brilliant and difficult question. If we ignore the Black Codes because they were racist, are we cherry-picking history? Does that signal a problem with the Bruin test itself? The lesson the lower courts took from this, and the lesson reinforced by the recent 6-3 ruling, is that the history and tradition test is not a free-for-all. The government cannot use the worst parts of our history to justify the erosion of constitutional rights today. As Pete Patterson argued in a SCOTUS blog analysis, the Black Codes were outliers, not the mainstream of American legal tradition. They were the very thing the 14th Amendment was designed to eliminate. So, what does this mean for the specific question? Are assault weapon bans dead? Let's look at the battlefield. Right now, the Third Circuit is sitting on a massive case challenging New Jersey's ban on AR-15s. The full court, or en banc, heard arguments recently. Notably, the panel had initially seemed ready to uphold the ban, but then the court unexpectedly voted to rehear the case with all its judges. That is a sign of deep division, and it is happening under the shadow of this new Supreme Court directive. In the Seventh Circuit, a challenge to Illinois' sweeping ban is pending. In the Ninth Circuit, California's ban is teetering. The analysis is now crystal clear. The lower courts must ask, is the AR-15 a bearable arm in common use? The answer, based on sheer numbers, is almost certainly yes. The burden then shifts to the states. They must show a historical tradition of banning weapons that were popular, commonly owned, and used for lawful purposes like militia service. They will point to laws banning dirks, Bowie knives, and certain pistols in the 1800s. But the rejoinder, which the Supreme Court just validated, is that those laws were often about concealed carry to prevent dueling and violence, not about banning the weapons outright from private ownership. Or they were targeted at specific criminal misuse, not the general public. The government's fallback position is the dangerous and unusual exception. They argue that even if common, the AR-15 is so dangerous, it falls outside the Second Amendment. But look at how the Sixth Circuit recently handled a challenge to the machine gun ban in United States versus Bridges. The court upheld the machine gun ban, but only because machine guns are truly unusual. The supply has been frozen since 1986, making them a rarity. The court's reasoning implied that if a weapon is both dangerous and common, the analysis shifts. The AR-15 is common. It is the best-selling rifle platform in America. This is the constitutional dead end for the states. The Supreme Court, in this recent 6-3 alignment, has essentially told them that they cannot ban a weapon that is in such widespread, lawful use simply because it has scary features or a high rate of fire. If the founders protected the musket, which was the weapon of the day for both militia and self-defense, then the Second Amendment protects the modern equivalent, the rifle that is the modern militia weapon and the modern self-defense tool. The court is saying that the right cannot be technologically frozen in the 18th century. Now, let's be precise about what this ruling actually does, because misinformation is rampant. This decision does not instantly strike down every state assault weapon ban. It does not make AR-15s legal in New York tomorrow. What it does is create a legal roadmap for the challenges working their way up. It tells the lower courts, like the Third Circuit, that if they cannot find a narrow, specific, and historical reason to uphold the ban that aligns with the tradition of regulating dangerous and unusual weapons in a way that doesn't infringe on common arms, they must strike it down. Practically, this means that within the next 6 to 12 months, we are likely to see a circuit split. The reliably liberal Ninth Circuit might try to uphold California's ban by squinting hard at history and finding some analog. But the Third Circuit, with its Republican-appointed majority, is very likely to strike down New Jersey's ban. Once that happens, the conflict between the circuits becomes undeniable. And when that happens, the Supreme Court will have no choice but to take a clean assault weapon case, and they will have already telegraphed how they will decide it. For the average American, this is seismic. It means that if you live in a state like Illinois, New Jersey, or California, the legal status of the most common rifle in the country is hanging by a thread that the Supreme Court just started to cut. It means that the ATF's ability to reclassify weapons and accessories is now under the most intense judicial scrutiny imaginable. If the ATF tries to ban a pistol with a brace by calling it a short-barreled rifle, the courts will now ask, did the founders ban accessories that made guns more effective? Probably not. There are 3 key takeaways from this moment that every American needs to understand. First, the Supreme Court has fully embraced a historical-only test. This is the most significant shift in constitutional jurisprudence in a generation. For better or worse, your right to own a firearm is now tied to what a consensus of states did in the 1700s and 1800s. This empowers judges to be historians, and it makes the outcome of cases turn on academic debates about colonial statutes. Second, the common use test is now the ultimate shield for gun owners. The court has reinforced that if a weapon is popular and owned by millions for lawful purposes, the government faces a nearly impossible burden to ban it. The AR-15, love it or hate it, meets that threshold. The burden is now on the states to prove that weapons like the AR-15 are outliers in American history, and that is a battle they are losing in the current legal framework. And third, this is not the end of the fight. It is the beginning of a new phase. The battleground shifts from can we ban them to how can we regulate them. We will see a flood of new laws focused on storage, training, insurance, and liability. The court has made it hard to ban the hardware, so the focus will shift to regulating the user and the environment. Before we close, I want to leave you with a final thought. We often talk about the Constitution as a living document, but in the realm of guns, the Supreme Court is insisting that it is a historical document. They are telling us that the answers to our most modern, terrifying problems, like mass shootings with semi-automatic rifles, lie in the dusty law books of the 18th century. Whether you believe that is a noble protection of liberty or a dangerous refusal to confront reality, one thing is certain. The law has changed, and the country will never be the same.